The health agency warns the disease could spread to people who eat meat from animals that are infected. Chronic wasting disease affects animals' brains and spinal cords and has been called the zombie deer disease. Most cases have been reported in states near the Rockies as well as the upper Midwest. Lisa Carter, NBC News Radio.
Hi, folks. If you're still paying for electricity every month, it means you haven't signed up for the Inland Empire's #1 money savings program offered by Horizon Solar Power. Just call to qualify your home, and Horizon will give you $100 plus pay your electric bill until 2020. It's that simple. Call, qualify, get $100 and no electric bill payments until 2020. So keep your money in your pocket and become energy independent today. Call 844-711-6996. That's 844-711-6996. Or click on one of our Stay Cool ads at KCAAradio.com.
It's time to say see you later, alligator, to embarrassing and troublesome issues with your skin, nails, and hair with all-natural Cayman alligator oil. Cayman oil is locally made, right in Louisiana, where people have been using alligator oil for centuries to treat all kinds of ailments. A drop a day of Cayman oil can help you say see you later, alligator, to athlete's foot, nail fungus, acne, eczema, rashes, dry skin, cuts, infections, MRSA, scars, burns, sunburns, and even ingrown hair and dandruff. If you or someone you know is tired of suffering with any of these skin, nail, and hair troubles, you need to visit mycayman.com to learn more about 100% natural, non-toxic, hypoallergenic Cayman oil and get a bottle today. Say see you later, alligator, with Cayman alligator oil at mycayman.com. That's mycayman.com. mycayman.com.
Miss your favorite show? Download the podcast at KCAAradio.com.
KCAA.
And now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen. I think we have another exciting guest today. Not as exciting, perhaps, as Roger Stone was last week, but Roger can't speak anymore. So all we got is the last interview, which is the one we did of him last week, just before the gag order was issued.
I think you got the last interview he did.
I think it was the last interview he did.
Yes, it was.
But and it was interesting because it was pretty current as to what the events were up to that point. After the indictment, before the gag order, a lot of dialogue going around. So I thought it was pretty good that we got Roger here last week.
In fact, the Mueller investigation supposedly said that they do have information or evidence that, hello? that they, is that your phone?
No, but I'm going to turn mine off.
They ain't mine. I know it ain't my flip phone. Anyways, the Mueller investigation supposedly has information saying that Roger Stone actually did have contact with somebody from WikiLeaks that he completely denies.
Well, what I said on the show last week, and I've been saying all along, is it may not make any difference that he lied at all. May not, because of the condition of called materiality. And if they can't prove that there was a crime committed of some kind, or some kind of illegal activity of some kind, then his statements wouldn't necessarily be material.
But how if he perjured himself?
It's the same. No, perjury requires materiality also.
Well, I mean, if he says that, didn't he go before Congress and say that he didn't have any contact with WikiLeaks?
Yeah.
Okay, but if they have proof.
So what? Even if he lied,
it's called perjury, isn't it?
No, it's not perjury unless you prove materiality.
Okay.
And materiality.
You're the judge. I don't know anything.
Well, look, I'm not. I don't know what Mueller has, so I can't comment on that.
Yeah.
And you can't come to any conclusions without knowing, what's on the full plate. So obviously we can't do much about that. But the reality is, there still are legal requirements of materiality and intent and a variety of other things. I think he's got a decent chance of winning. Look, the two witnesses against him are two guys who made statements that were totally inconsistent with each other as well, Corsi and Credito.
Yeah, Heckle and Jekyll, you mean?
That was a good group.
It was. It was a great cartoon.
Maybe it was Jekyll and Hyde. I'm not really sure. But the fact,
That's me.
The fact of the matter is that it's there's really no way of telling because it depends on what judge you get. I don't think it was a very smart thing for him to do to challenge the judge.
He got Manafort's judge.
That's why I thought it was foolish to make that move. I wouldn't have done that because all you do is tick off the judge you got because it's going to get denied anyway.
Yeah.
So I'm not so sure that was a great call. But anyway, let's get on to the subject at hand for today before I go off into a wild tangent. But I'm a real believer in the requirement of proof. And there's a burden of proof requirement that the people have. And if you look at the motivation behind it, and it may not have been really legitimate, maybe it was just to entice him to do something at Dern or whatever that may have been. But the fact of the matter is, we will wait and see.
Yes.
So anyway, today's guest is Jeff Nadrich, who we had on the show not too long ago. And he is a specialist in what's called mass torts. And I'm going to talk to him about what a mass tort is.
What is a mass tort?
I'd like to think of something clever, but a mass tort is where there's like you take Johnson & Johnson. At one time, they were producing baby powder that ultimately caused serious cancers in a lot of women, maybe even some men. I'm not really sure. But that's a mass tort. Anytime you have multiple victims, many multiple victims, that's what's considered a mass tort. There's several ways of going about it. One's a class action.
That's what I was going to ask you.
And I'm going to ask Jeff to tell us the difference between class action and mass tort, if there is any.
That's what I was going to ask you.
And
I'm just saying, I don't know.
Go ahead, put me on the spot, Gary.
Well, no, that's why you have the guest.
No, the guest really specializes in this. So
cool.
And I thought of it because I heard a story about a new potential mass tort that's out there. If you watch television at late night, usually, you'll see these advertisements for mesothelioma.
Oh.
My son corrected me the other day because I couldn't spell it right, and he's a doctor.
Is it mesothelioma?
Mesothelioma.
It's so irritating.
It was definitely irritating. It caused people to die.
Well, I'm just saying the whole commercial.
In fact, from what I understand, I'm not really sure. I think it's incurable.
Oh, really?
It's like a lung cancer. I don't really know that, but I think it's reported to be incurable.
That's terrible.
So, but I was thinking, many, many years ago, I guess it's probably 30 years ago now, there was no such thing as lawyer advertising. You weren't allowed to do that.
Right.
You couldn't do anything other than hand out business cards.
Yeah, we talked about that a couple of weeks ago, actually.
And this is where, it's come full circle, actually, because in a case, the Jacoby Myers case here in California, the court said you can't prevent lawyers from advertising. Violated their First Amendment rights and a variety of other things, I suspect. And so lawyers started to advertise. That's why when you're driving on the freeway or you're driving on even on a straight road, you look to the right and there's the bus, there's the big sign of the guy standing there or the gal standing there with the scales of justice behind them or some books or whatever it is, giving you some authenticity.
So cheesy.
Selling.
So cheesy.
And I used to think that the lawyers that did that or had the advertisement on the bus stop or these big billboards and whatever were just basically low-end bottom feeders. They were just looking to grab the business and just do a mass mill operation. And to some degree that was true. We mentioned this guy's name. We didn't go. No, don't.
Pappy Parker?
Don't.
No, that's the fried chicken at Bob's Big Boy.
We're not going to go into any specifics, but there are lawyers who have been doing this for many, many years.
Yeah.
And they don't really do the work themselves. They just, for all practical purposes, bring the business in and then refer it out to some other nondescript law firm with whom they have a business relationship. And there's a referral fee because you brought them the piece of business, even though you don't do the work yourself. There's some little requirement that you're supposed to do something, but I've never seen that ever enforced. In order to to get a referral fee, you're supposed to do something.
He stamps his name on the document, one document.
but nobody enforces it. It doesn't make any difference.
Of course.
But I've come to a different conclusion.
Oh, really?
Yeah, there are some very good law firms that do have quality work. They get the business that way, but they're just good marketers. People are using the internet. People are using other ways of marketing.
Well,
and Jeff Nadrich is one of those people.
Well, times have changed, Judge.
Oh, he's very, very sophisticated. He really knows his stuff. He knows how to put the deals together so that he can maximize the results for some of his clients. That's different than some of the regular mills, which just wants to turn the cases over. And there's a big difference when you do mass torts and you do class actions and things like that. You don't have the same relationship with the client. In fact, you almost have no relationship with the client. These guys are hands-on. So I was impressed when he was telling me. I spoke to him not too long ago, and he was explaining to me about this new mass tort that's out there. And I'm sure he's going to tell you all about it because I asked him to do that. And I think that's doing a very good public service for the public.
What is it?
It has to do with your ears.
Your ears?
Yeah.
Huh?
It's the Dumbo syndrome. No. It has to do with ear issues.
Oh, really?
Yeah, and he explained it all to me, even with all the medical terms.
Ear.
And What'd you say?
I said what?
What?
That's interesting.
Okay, we're gonna talk.
Ears.
We're gonna talk to him at 4:30.
Okay.
Keep your ears open.
Wide open.
Okay.
Can we take a break?
Absolutely.
I need his phone number, by the way.
I'll give it to you.
All right. Hey, get the Judge's book, From the Trench to the Bench, available on Amazon.com. We'll be back after this.
10:50 a.m. KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, the good news is we just spoke with Jeff, and he's going to call in at 4:30, and he's not been given any advanced questions or anything, so everything is going to come off the top of his head, or my head, whatever it is. But I'm trying to think of questions that interest the public. This falls within at least two of the categories of the four categories that we have for the purpose of the show. One is informational. People want to know. They may have something come up in their lives that's similar to it, maybe not, but they want to know. They're thirsty for knowledge. Others are looking for guidelines. What do they do if? And people are doing a lot of this lawyering based on the internet, social media.
Yeah, well, how do you even get involved into a tort or a class action lawsuit? How do you even find out about it? How do you become a part of it? That's something I'd like to know.
Well, you hear with the Dalcon Shield cases, in which I had a Dalcon Shield case. That was the intrauterine device that caused ovarian cancer. And there were many, many, many women who were victims as a result of that. And they structured it a class action suit where there was a committee, because all the discovery was done by a committee, handful of lawyers, as opposed to the hundreds of lawyers, thousands of lawyers perhaps, that were involved in trying to recover for their clients. And I was just thinking about the fact is most of the time in these class action lawsuits, most of the time, you get a little notice that you're in the class.
Yeah, I get those.
Somebody told you, somebody gave them your name.
Yeah.
Or they ran some database and saw that you bought a widget somewhere, and
yeah,
you know, back in 2026 or 2005 or whatever the year.
Yeah, I've had that happen a couple times. Actually, I've had it happen 3 or 4 times where I get these notices and I don't know what to do with them.
Well, actually, in actuality, believe it or not, probably 95% of the time, just sign it and send it back.
Okay.
Because you have an option. The option is to stay in the class, or you can do what they call opt-out. Means you can take your lawsuit and do it on your own. You're not stuck with anybody else is representing you.
Yeah.
Or other people, because you know, at the end of the day, you run to the mailbox, you see this notice that from the federal court that the case has been settled and whatever.
Yeah.
And you're so excited, and you open up that envelope and it's $4.12.
Exactly. I did. I've gotten a couple of those for like $1.82.
Yeah. Or the next time you go on the flight, you get to sit in the back 5 rows or whatever. They have some kind of promotion that doesn't really cost them anything.
I like sitting in the back row though.
Well, there you go.
Closer to the bar. Or the drinks.
Not really. Most planes, the bar is in the middle.
No, well, I'm talking about not the bar, but you know where the drinks are at. Forget it, Judge.
Okay,
keep doing your thing.
Look, the bottom line is that the only people who really make any money in these class action lawsuits are the lawyers.
Yeah.
Because they're getting 40%, 50% off the top, and they get all their costs back. So what's left is divided among the throngs of people who filed these papers.
Yeah, it's weird.
But if your case is worth $26, you're not going to file your own lawsuit because it costs you more for the filing fee.
But I mean, why would you even, if it's only like a couple bucks, why would, what's the point? Is this for the lawyers to get rich?
No, because you can't say in the opening documents that they're only going to get whatever they're going to get. It just talks about how terrible the conduct was of the defendant and how they're going to go after all of them and yada, yada, yada.
Let me ask you a question, Judge, and be completely honest here. I mean, these class action lawsuits and all this other stuff, I mean, really, the lawyers are doing it to get rich. They don't care about the clients. They don't care about what to take something off the market. It's all about them getting paid. Correct or incorrect?
That's kind of an exaggeration. There are some lawyers that are doing it for the right reasons.
Okay.
But it's a great moneymaker. Look, the bottom line problem with class action lawsuits for the lawyers, first of all, they don't take cases that are not going to settle. The bottom line is that they're out of pocket all this money in the meantime. The printing costs, getting all the approvals through the court and the mailings and whatever, and the expert witnesses that you have to hire, these people are investing their own money in these cases. These contingency cases are not sure things, although they pretty much have it down to a science.
Believe me, I don't think they're going to take a case that's on the fringe. Do you? I mean,
yeah, I do.
You really?
Yeah, because
the tobacco industry is a good example. Remember they did a class action lawsuit
and the Ford rollover case.
Yeah, there's been a few that later on the line.
A lot of these cases they have whistleblower. I think in this case that we're going to talk about, Jeff's case, there's a whistleblower.
On ears?
Somebody heard the blowing the whistle.
Or didn't.
Yeah, or didn't. But the fact of the matter is that these cases are analyzed, and they figure that probably 95% of them settle. Why do they settle? Because it's cheaper. But if you look at the asbestos cases, that's another example of mass tort.
Yeah.
They're still going. You think this mesothelioma book that they sell or they give away free is really to help you guide through yourself through the medical issues. No, it's basically to tell you that they know how to do these kind of cases. They could sign up one of these cases off the ad that runs at 2 o'clock in the morning or whatever it is. They can make, if you figure on just a 40%, which is the normal contingencies, they can make 40%, and a lot of these cases are ultimately become either wrongful death cases or personal injury cases. They're worth 7 figures. A lot of these people are on life support for many, many years. So if you get 40%, 40% of $1 million is still $400,000.
Off of somebody's death or
but
dying.
You know what? What would they do otherwise?
I know, but I'm just saying it's sort of sad.
No, but the purpose of this whole thing is to get people whole at the end of the day. That's the way it's supposed to be.
Yeah, but it's
what lawyers do.
I know, but it's sort of when you're talking about this stuff, with the cancer thing or whatever it is. I mean, it's just sad that they're basically off the backs of people that are dying.
But those people, if they get something that makes their lives easier through to the end, didn't that accomplish something? There's not what lawyers do generally on whether it's a personal injury or a business case or whatever. The lawyer's job is to maximize the potential recovery for the client.
Yeah.
Doesn't always work that way. Sometimes the clients are not cooperative. Sometimes they don't always tell you the truth. Sometimes they hide information. It's not always such an easy ride. Everybody thinks that the lawyers should just sit around rolling it in and get wheelbarrows so you can go to the Brinks truck. Not so. Many lawyers don't make a living. A lot of them go on the bench. I hate to admit that.
Oh, yeah, you got
I know that's really true. I know people don't like to hear that, but some of the judges are there because they couldn't make a living, and they knew somebody.
No, I
or
know.
they ran for the job. Just because you got the title doesn't make you smart, doesn't make you nice, doesn't make you intellectual, doesn't make you anything other than you knew somebody.
I dig it.
I mean, it's nice. The title is a nice thing and all of that, but the reality is some of the judges really don't deserve it. Really don't. Some are terrific. There are appellate judges that are brilliant, that really educated, sophisticated. Like there's an appellate court judge here in Los Angeles, Larry Rubin, who I've known for many years. Bright, nice, real, what I call a Hamish guy, a really neat guy. Been doing it now. I bet he's on the Court of Appeals for 30 years. There are some very, very good judges who take it very, very seriously.
Well, I hope so.
Unfortunately, there are some that are not.
Yeah.
We've been through the stories about the judge. I told the story. I'm going to tell the story while we're waiting for him to call.
Which one, the drunk one?
No, not the drunk judge. No, this was in court when we were like 40 lawyers sitting in the audience. We were all waiting for the calendar.
Yeah.
And this judge, who was a miserable human being, I'm not going to mention his name, but he was a miserable human being, and everybody knew it. He was the best lawyer in the building. You know how we knew that? Because he told you. And the fact is, he said to this young lawyer, I can almost picture it now, says to this young lawyer, do you have your bar card? You know, the Bar Association gives you a card so you can get into the jail and whatever,
right,
and get out. And so he says to him, do you have your bar card? And the kid looked up and he said, well, he stumbled, he didn't know what to say, because this guy's a big, imposing, tall guy. And he says, why, Your Honor? He says, because you're incompetent. I don't believe the bar would give you a license. He said this in front of 40 lawyers sitting in the audience. How do you think that kid felt? Not very good.
Terrible. I mean,
And then he answered me. He says, Dad, you could treat me better.
Yeah. You have to show me up in front of everybody.
The bottom line is you get the good, the bad, and the ugly. And so when you talk even about Roger Stone, you don't know what's going to happen at the end of the day. That judge may be very much inclined to believe in the strong burden of proof argument beyond a reason, but I may not let the evidence in. Some of this stuff may not get in, because I was talking about those 2 witnesses. Their credibility is at stake. What they're testifying to is hearsay, what he said to them. Now, normally it's an out-of-court statement made by a party who's not subject to cross-examination. So you say, well, he's a defendant, so he's subject to. But there's a rule that if you take the fifth, you're deemed unavailable for purposes of these evidentiary exceptions. And so the chances are these two characters that are going to come in, you can call them Jekyll and Hyde if you want.
Jekyll and Jekyll.
Jekyll and Jekyll. they're going to be subject to serious cross-examination, motive, interest, and bias. They said lots of different things. If that's all they got, other than business deals, they don't got much.
Well, you know what? The only thing is that judge, like I said, was the Manafort judge. And that would scare the hell out of me if I was Roger Stone. That's all I got to say.
I wouldn't have made that motion if I were them. Frankly, I thought that was a mistake. But, why they did it, I have no idea. I told the story, I think, on the show last week or the week before. There's a challenge in California that you can make to any judge. You get one challenge. You get one challenge for sure. You don't have to have a reason. It's called the 170.6 challenge. And for me, I was a judge pro tem, meaning people had to stipulate to my hearing these cases.
Right.
And once they stipulated, that was the end of it. You can't wait until the first ruling and say, oh, by the way, I want to kick you off, right?
Hey, I made a mistake.
Somebody tried to do that. Said, I think I'm going to exercise my challenge. I said, well, you had your opportunity to do that. You didn't do that. It's untimely, and therefore your request is denied, period, the end. How do you think they must have felt? There's one judge, in a lot of the cases that I had, I was the sole determiner of the fact and the law. How do you think it would have felt?
I wouldn't want you as my judge. I'll tell you that. That person wouldn't. I'll tell.
Well, it depends on how seriously you take your job.
I'm just saying.
I wouldn't allow that to get in my way personally, because it has nothing to do with the value of the case. Just like the people who were in front of me sometimes was miserable and nasty and angry and out of control. Ultimately, it made no difference in the outcome. I told you the story of Beverly Hills. This crazy lady, she actually tried to approach the bench. The bailiff had to grab her. And the fact of the matter is, she won because she was right.
So that the
other guy was wearing a suit and tie, was very, very pleasant and all, but he wasn't right.
You're a better man than most, Judge. Some people would take that personal. I'm just saying. Whatever.
You can't do that.
I know. Well, you're a good judge, as you're saying. You're a good judge, and there's judges.
I'm not saying I'm a good judge. I'm just saying that I don't allow that to get in my way. I wouldn't say that either.
Okay.
I thought I was pretty good.
All right,
really,
there you go.
Even though it sounds
Please.
Immodest and it sounds egotistical.
Stop. You're a good judge.
I thought I was pretty good.
All right, we got to take a break. Hold on.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, we have Jeff Nadrich on the phone. And Jeff, are you there?
I'm here.
Oh, great connection. Last time I think we were on a cell phone, and it wasn't so clear. This is very good.
New computer, though, Judge.
Anyway,
that's why.
This looks like the same computer to me.
It isn't.
But bottom line is, I'd like for you to tell the folks what a mass tort is.
Well, thank you. Thank you, Judge, for the opportunity to let me share with you about this very important subject to literally millions of Americans. We are mass tort lawyers, and that means that we represent people who have been injured by, and I'll give an example, Judge, a defective medical device. Let's say, for example, a defective hip or a defective knee, which was used the wrong measurements in the design process or the wrong metals in the design process, and it failed after 3 to 5 years. and it sold to its clients being hospitals, hundreds of thousands of these bad hips and knees. The doctors of these hospitals implanted them in the patient, and the patient then had tremendous pain and had to have them replaced in 3 to 5 years. So these patients have a claim against the manufacturer for what they did, in this case, let's say the wrong metal, which is what's called negligence, or they fell below the standard. So instead of pursuing a class action where these victims or these patients would receive very little, if anything, of a recovery, we sue on behalf of the patient or the victim individually. So if we have 500 or 5,000 bad knee or bad hip victims, each person has an individual claim against the manufacturer so they could obtain the full compensation for their injuries. So it's much, much better for the common plaintiff out there, the common everyday person that we represent. Whereas a class action, I always think of it in terms of if American Express charged a hidden interest charge, or Verizon did the same thing on its cell phone charge, where everybody suffered some small amount, a few pennies on the bill. That happens, lawyers will bring that, and that will be resolved, but unfortunately, a class plaintiff will receive something. The lawyers will be paid, the defense lawyers representing Verizon or American Express will be paid, but the consumer in a class action will literally get pennies. And so that's the difference.
Well, don't they structure those in class action cases where if you're in class 1, you get X percent, class 2, you get more, class 3, you get the max? Isn't that the way they worked it out in some of these medical cases?
On individual cases, they are mass torts. So, yes, in the sense that in a settlement, let's say that they settle all the hip cases that qualify with certain injuries or from a certain manufacturing date to another manufacturing date, then there'll be a grid based upon the revisions and based upon the proximity to the original implant, and each person will get a valuation. So that's how it's done. Maybe you're thinking class, it's called class, but it's really an individual settlement. And that's what we're all about, is because then we can get our clients the most compensation for their injuries.
But in a class action, don't they also structure it, you called it a grid, certain people got more than others, even if there was small amounts?
Well, I think we were talking about the same thing. We're just talking about semantics now.
Okay.
So a lot of people will call them class actions when it's a mass tort and it's an individual settlement. So they're the same. I always use the Verizon versus the hips and knees to show the compensation difference, where when you sue individually, you're suing for yourself and for your own claim, and therefore it's better for the person who's been victimized.
And you finance these lawsuits by paying for all the costs and the experts and whatever is necessary?
Yeah, we work with the best law firms around the country, including ours. We have offices throughout California, and we're contingency lawyers, so we finance everything. And we will pay whatever it takes. We have the resources, and there is never any cost at all to our clients.
So there's really no downside.
Excuse me?
There's really there's no downside to the client.
No, not to the clients. It's to somebody who qualifies, it's a win-win. We're very active in current mass torts in Essure, which was a horrific birth control device, hernia mesh, which was a propylene plastic mesh product that was placed in for hernias, large hernias, which has been a disaster for the patients. Those are some significant ongoing projects. And now we're very much involved in the military earplug.
That's the one I was telling Gary about before we started the show. It's called the military earplug. So tell us what military earplug is.
This is a very sad story, but it's a very, very interesting story about what happens in today's world. There's a company called Aero, and Aero is a small corporation, AEARO, and they had patented technology on the supposed earplugs, which would effectively silence large incendiary devices to the ear canal in a military setting. And so 3M purchased the company. 3M is one of the largest corporations in the world in the United States. They're involved in every kind of safety practice where they're number one. And so they purchased this company, and it made it into a wholly owned subsidiary of 3M. 3M is a Minnesota corporation, and they were acquired in I think around, not quite sure of the date. But what happened is that 3M took it over and took it to market by selling it to the Defense Logistics Agency, which is the sales arm of the Department of Defense. And they based these dual application earplugs on specifications that unfortunately were not true and correct, and the government relied on those specifications. So the government made its purchase and ended up purchasing literally millions of these military earplugs and issued them to every single service member who was deployed in any kind of battleground area, including Afghanistan and Iraq. That means every single service person, Judge, who went in and out of these, every deployment was issued these earplugs to use, maybe as much as 1 million of these earplugs. They were exclusively issued to servicemen from 2003 to late 2015. The problem is that they didn't fit correctly. 3M knew they didn't fit correctly and knew that they were unfit for their purpose, which was, number one, in communicating with each other, and number two, in protecting the service person from an incendiary device, artillery, whatever happens in military combat. So they misled the government in its testing. So everything went along in all of these years until a whistleblower lawsuit occurred. And whistleblower is a federal case in which the Department of Justice takes over a case by somebody who informs based upon fraudulent activity of a private company. And the Department of Justice brought a case against 3M for faulty and fraudulent specifications from the information they obtained from an insider, Judge. And in 2018, the 3M company settled for $9.1 million, admitting that they had defrauded the government by false specifications. The result of this whistleblower lawsuit has caused this, what we call mass tort, because it's come to light that tens of thousands, maybe hundreds of thousands of military service members have developed significant hearing loss and or tinnitus as a direct result of these faulty earplugs, which 3M Corporation, Judge, admitted its liability when they settled the whistleblower lawsuit.
So basically, I don't want to say it's like shooting fish in a barrel, but it sounds like liability is established by virtue of some kind of judicial estoppel or res judicata or some other concept, and it's really just a matter of damages.
No, not at all. There's something, no. The whistleblower lawsuit, the issues are different from an individual bringing an injury lawsuit against 3M. Let me just say that the money that the Department of Justice obtained, the $9.1 million, the whistleblower was paid approximately $1,198,000, and the balance went to the Department of Justice, which went to the military. There's no service member who suffered hearing loss, and I have so many clients that have suffered from 20 to 90% permanent hearing loss, not to mention all the tinnitus cases that we have. None of these servicemen obtained 1 penny from that settlement. The only route that they have, Judge, is to file a lawsuit, which is what we're doing for them. But it's not the same, and liability isn't clear, because there's something called the government contractor's immunity defense. And that is a very strong defense, which they will assert that they have immunity because they contracted with the federal government. So we have to mount an attack to succeed and to get over the hurdle to beat that defense.
How do you do that?
Well, we have ways, and we have lawyers in-house that have been very successful in similar type cases.
Hope so.
And it really will depend upon, Gary, on whether or not, what information did the federal government have as to these faulty, fraudulent specs. Did they independently review them? Did they have their own analysis? Did they bring them to their own lab? Or did they solely rely on what was provided to them by 3M? Thus far, the evidence is looking like the latter. But discovery is just beginning. The lawsuits have just been filed, and we will see. But we are very positive on what we feel the outcome is.
I guess you have to be, considering you're going to be paying for it.
Well, we are very selective on what we do, Judge. And this is a project that we are very excited about. And it's the least that we could do for these service members who are literally heroic in what they've done for all of us.
Are you suing 3M? Excuse me, Jeff. Are you suing 3M or are you suing the federal government or both?
No. 3M.
Okay.
3M.
Okay.
The federal government was duped.
Okay, so it's 3M. Okay, so you're going after 3M.
3M.
Pretty good deep-pocketed defendant, so I don't think you have to worry about collections.
No,
what do you think the chances are you're going to settle these, like the asbestos cases?
Well, asbestos is interesting. When asbestos started, asbestos was hardly known to the public, and there was really no science behind the liability of asbestos and mesothelioma. But to answer your question, the mass torts traditionally take 4 to 6 years. This has just started. And maybe in 2 or 3 years we'll have some bellwether trials, which means trials of different selected types of injuries to see if they are successful, and if they are, what the value would be, so that after a number of bellwethers are tried, then all the parties and the judge has an idea of what the settlement value could be.
Now, Jeff, is 3M not wanting to settle or denying it, or what are they doing? Because these are service people. These are people that have fought for us, fought for our country. You think that 3M would not want this to go on and on and on in the court system and just settle and bury it,
No, Gary, on the contrary, 3M will fight and fight and fight.
Unbelievable.
So there's a saying in our industry, not a penny to tribute, millions for defense. And this is just another consistency. Tribute meaning like in the Roman Empire, where you'd pay tribute to the Roman tribunals. Whereas defense. So no, we don't anticipate any kind of quiet settlement. We anticipate scorched earth for years.
That's sad. That's really sad. It's really sad.
Well, it's business. It's business as far as 3M is concerned. And we're involved in many cases like that, and that's just the way it is until quietly these inventories settle, where the board of directors of these corporations decide that it's in the best interest of the company and the earnings to settle a case. But it takes a long, long time, and this project's just begun. We're talking to a lot of people all over the country who've suffered hearing losses, and you wouldn't believe the emails and phone calls we're seeing. It's tragic. It's just a shame. So that's a very exciting project that we're doing. We do it on a complete contingency, and the clients, there's no cost to them. We do all the work. We have auditory experts. We are having an expert review where we review all the VA medical reports and everything for the client. And so hopefully some of these people have private health insurance, but a lot of them go through the VA.
You told me something the other day I want to cover in a minute, but first I would like to ask you to provide your contact information, because there are people out there who are going to need somebody like you, and they should know where you are.
Maybe military men,
Of course.
Well, Judge, Let me give you our 800 number and the name of our website, if that's okay.
Sure, of course.
Our 800 number is 800-718-4658. Let me repeat that one more time. 800-718-4658. And our website, which is very easy, is Personal Injury Law, LAW, CAL.com. So that's Personal Injury Law, CAL.com.
You're involved in those fires too, aren't you? The big fires.
We're very involved. Yes, we're very involved in the Malibu fire cases. We just met with a family, a widow of a doctor who lived in Malibu who died of pneumonia as a result of the fires. He was 81 or 82 years old this week, this past Thursday, I believe. So we represent people who have lost their homes and their businesses and have suffered personal injury from the Malibu fires and the Woolsey fires, which was up in Agora Hills, Bell Canyon throughout Malibu, as well as the Camp fires up in Paradise, California. We do that on a contingency as well.
You mentioned something very
Judge.
You mentioned something very interesting to me the other day when I talked to you, and that is many of these people who have suffered property damages in these fires have been paid back by their insurance companies. They've gotten all their money back. They're fixing the house. They got the additional expenses taken care of and everything else. And you mentioned that there's still opportunities for those people to recover damages that were not paid by the insurance company, talking about emotional damages and personal injury damages, things that would not be covered by the policy. How's that working?
Well, that's great, and thank you for bringing that up. People in Malibu think that because they settled or the insurance company paid them their policy limits, that they could not benefit from the separate claim against Southern California Edison, who we believe caused the fire. And they're incorrect. There is an entire separate, what we call liability case, meaning a whole nother case for these people that they can benefit from suing and allowing us to sue on their behalf, Southern California Edison, for causing the fire. The funds, the compensation that we will get them when that case is over will be above and beyond what they got from the insurance company, and they do not have to pay the insurance company back what the insurance company had paid them previously.
Why is that?
Very important point.
Well,
because this is additional damages from negligence from a separate party. A separate party that caused negligence that fell below the standard of care in California under California law, whereas in insurance, they had a contract with their insurance company, and that's why they paid the premiums. And in the insurance contract, the insurance company had to comply with the contract, which was paying them their policy limits. So in one is a contractual form of recovery, and the second is a separate tort or negligence form of recovery. So they have the opportunity for both, because we intend to find a third party, in this case Southern California Edison, and up north Pacific Gas and Electric, responsible for the fire, and therefore everything that these people suffered from, they can obtain compensation under California law against these utilities.
Sounds like there are a lot of remedies out there for the folks that just don't know about them. And
I believe so.
Well, part of our
Judge.
Part of our program really here is to inform the public as to what remedies are available for them, not to promote anything, but basically to tell them it's there for you if you fall under that definition. And so I appreciate your sharing with us some of these. I'm sure you have others. I was telling Gary before about the Johnson & Johnson, the talcum powder cases.
I remember that.
A lot of those people recovered a lot and were able to live the rest of their lives out that might not have been able to do that.
No one has recovered anything on a Dow case, Judge. What happened is we have judgments, but nobody has recovered anything from the manufacturers of talc.
But you got a judgment.
Their ovarian cancer.
Judgment's not so bad either.
Yes, but the judgment is against Johnson & Johnson, the most difficult pharmaceutical company, bar none, is Johnson & Johnson.
And they haven't paid out anything.
Not 10 cents.
Oh, God.
These
companies.
Well, it's a good thing. It's a good thing we have people like you out there that are fighting for the public. That's really something nice to say about you. You're making this part of your experience and serving the public is one of the things that we're supposed to do as lawyers. And I want to thank you for being out there in front for all of us and for being a guest on the show. We'll have you again, maybe down the road a little bit more, and you can fill us in on how it's going. So thanks again, Jeff.
Thank you.
Bye-bye.
Thank you. Have a great day. Thank you, Gary. Bye-bye.
Thank you, man. This is crazy with these companies not wanting to.
Oh, no, but you see, this is not just this kind of lawsuits. This is all lawsuits. There are very few companies out there. I shouldn't say very few. I haven't got the statistics on it. But part of the plan is not to pay money out to claimants, insurance companies especially. Because you know the old float story, right? I told you the only float in town isn't at the Rose Parade. They're using your money to invest. If they got to pay you, that comes off of earnings. And they're looking at earnings. They don't care about the rest of it. It's all about the earnings.
It's a rigged game, man. It's a rigged game.
I suppose it is. Is that it for today, Gary?
No, we got a few more minutes, a couple more minutes.
Well, I was going to say... we
got to take a break, though.
We started talking about advertising. We'll talk about that after the break.
Okay. KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
So we're going to come full circle because we started talking about advertising and things. And my initial, I suppose, somewhat conservative view about advertising, but I've kind of changed my thinking about that. It's the law firms like Jeff's, and he's not alone. There are some very, very good ones, high-end, high-quality firms. The thing you got to be careful about if you're a victim of some kind and you want to make a claim or you want to participate in some lawsuit is you got to make sure that the firm that they have has the money to finance it. These experts are very, very expensive. If you're going to have your individual case and you're looking at a loss of earnings claim, you're going to need a forensic accountant. You're going to need doctors because they need to be able to talk about the liability aspects, knowledge, ability to make changes and things of that nature. So you want to know what assets these law firms have. Many of them are very well heeled. They make their money based on the turnover. We've talked about sometimes contingency lawyers are not the best answers because they will look to settle them faster and quicker and cheaper and just to make sure that they get paid and not have to spend overhead. So you want to be careful about that. Go in and talk to somebody. Don't just make a phone call and have some salesperson on the other end talk you into doing anything. Talk to the lawyers that are really going to do the work for you. You want to know who they are, and you want to know if they can afford to pay for these costs. And if they tell you they don't pay for those costs, then you should find out which the quickest way is to the door, because those people are not going to be there for you when you need them.
Let me give out Jeff's website one more time, personalinjurylawcal.com.
Right. He's a nice guy. I met him actually physically. I had lunch with him, and he's a very smart guy, very motivated, devoted, gets up early in the morning, and works very hard for his clients. So I don't do endorsements on the show.
No, it's all right.
From my limited experience, I think he is really well-versed, smart, and savvy. That smart is one thing, savvy is another. Street smart.
Yeah. Well, I mean, to hear that Johnson & Johnson has not paid a penny from all those, they lost.
But you know, I'm a victim of all of it because I read all of the verdicts that come down. And I'm thinking that all these monies that are coming out of Johnson & Johnson to pay these people, this was a verdict for $4 million. Oh, Johnson & Johnson got hit for $4 million. But if they're not paying it, it doesn't make much difference.
I mean, it's just
they'll get it sooner or later. By the way, they'll get it sooner or later. The judgments, unless they're appealed and the judgments are reversed, which is unlikely, someday you'll be able to collect it. I can tell you the story. One time I chased an insurance company up in Northern California. We had a judgment, and they weren't paying. I sent the marshal in, and we were grabbing the computers. And I got a phone call from the general counsel, big company, big guy. He says, "What are you doing?" So I'm just collecting the judgment. "Well, you didn't need to do that." I said, "Yes, we did." He said, "We'll get you a check in the morning. Call up the dogs." And I did, and we got paid.
Well, that's cool. I mean, but listen, I mean, these big, huge companies like 3M and Johnson & Johnson, you know, I mean, from what he said, 3M knew about all this
Look
stuff.
Look at Mansville and Robbins and Ford, and it happens all the time.
I don't know what I need.
Well, the bottom line was there are people out there that can do some good for you. Just be careful who you pick.
Yeah, no, I hear you. Well,
okay, so we'll see you next week.
Okay, Judge. If you want to get the judge's book, From the Trench to the Bench, go to Amazon.com. If you want to ask the judge a question, email him, askjudgeherb@gmail.com.
And if you want me to refer you out to somebody, I'm happy to talk to you about it, but I don't generally endorse anything or anybody. But if I know somebody and I have good reputations, I certainly will tell you that.
All right, cool. I'll see you next week, Judge.
KCAA Loma Linda, 1050 AM, 106.5 FM.